I'm really glad you could join us today. I'm here to talk about jury trial process. What are the steps of how a jury trial works? And I'll walk you through from start to finish on that. It's relatively simple steps, and I'll boil it down. So first of all, I do have a video on jury selection. So there'll be a whole panel of jury members that are brought to court, and there'll be a jury selection. The judge might start with some opening comments, and you're vetting jurors to find 12, and you can watch that video if you like. Now, once you've got the 12 selected, the judge might have some opening comments about how the trial is going to work for the jury, so they understand how they're going to be proceeding in the next 7 days, say in a sexual assault matter. Now, what happens then is the Crown Attorney does an opening statement. So they'll stand in front of the jury and give an outline of their anticipated evidence, the witnesses that are going to be called and how the witnesses are going to flow, and what he or she anticipates they're going to say. At that point, then, the trial commences in terms of calling witnesses. So the Crown will call, for example, the victim, the alleged victim or complainant, any police witnesses or other witnesses. And how does that work then? So let's take the complainant, the victim of the crime, alleged victim at least. Now, the Crown will call them examination in chief. So they'll ask them who, what, where, why, when type open-ended questions, where the victim will give their version of events from start to finish, kind of in a chronological order. Defense counsel is then allowed to cross-examine the victim. They're allowed to use leading questions like, you were at the store, for example. In other words, the question suggests the answer. And you're trying to create improbabilities, inconsistencies, this type of thing, to create a reasonable doubt. So the trial will proceed in that matter. The Crown keeps calling witnesses. There's examination in chief, followed by cross-examination. By the way, defense counsel is allowed to re-examine if they need to, their own witnesses, if they're allowed to clarify, and I'll get into that. So you finish the Crown's case. Now, defense counsel is allowed to do an opening statement if they're going to call their client. Now, in most sexual assault trials, the defense calls evidence. Not all, you don't have to, but in most you do. So you'll do an opening statement about the anticipated evidence. You might talk a little bit about the burden of proof and proof beyond a reasonable doubt, so to educate the jury on that. And then you call your client and any other evidence that's required to show your defense. And the same procedure, examination chief, where defense counsel is asking open-ended who, what, when, where, why questions. The Crown's cross-examining, they're allowed to ask leading questions. And then, of course, defense counsel is allowed to re-examine if there's clarifications or an area was uncertain that the Crown cut off the witness and that needs to be explained more, if I might put it that way. Now, we're at the end of the evidence. The defense closes its case. And what happens next? So the judge has to prepare a jury charge to the jury. This is kind of a summary of the relevant law and evidence that goes to the jury. And those charges can be lengthy. I mean, I've seen them 1.5, sometimes 2 hours. Some judges are pretty succinct and might be able to do it in an hour, but that's rare. But what happens is the jury will typically go home for, say, a half a day. The judge presents the, say, 60, 70, 80-page charge that they prepared, and the defense counsel and Crown has a conference with the judge where they critique or make suggested changes, so every party comes to an agreement about the judge's charge to the jury. So the jury will come back, and if defense counsel called evidence, which they normally do, or at least our firm normally does in a sexual assault matter, I will do a closing submissions to the jury. I like to keep mine, I mean, people's attention spans is only so long, so I like to keep mine between 45 minutes to an hour in a sexual assault trial. You're arguing that there's a reasonable doubt and the case should be dismissed, found not guilty by the jury. Then the Crown Attorney will give their closing submissions. Same idea, they're trying to convince the jury that they've proven their case beyond a reasonable doubt. Now, in a jury trial, if the defense calls evidence, you're not allowed to give a reply. So I can't stand up and after the Crown does their closing submissions, I'm not allowed to stand up and say, here's more submissions. I'm trying to respond to that. So what I always do in my closing submissions, I say it's my last opportunity to address you. So when you hear the the Crown, you may think there's a legitimate argument Mr. Kruse could have made. Well, I'm not allowed to. So you provide that legitimate argument. And then, of course, following that, the judge will give their charge, their closing charge to the jury, and then the jury starts their deliberations. And in order to find guilt beyond a reasonable doubt, you have to have 12 unanimous juries. Conversely, to find not guilty, 12 unanimous juries, not guilty verdicts by the jury. And if they can't all agree, it's a mistrial. The trial has to start all over again at another jury sitting. So that's the way our jury system works. It's and typically I find the typical sexual assault trial, jury trial that I've done over the years, 4 days would be very quick. I find 5, 6, 7, sometimes even 8 days, depending on the number of witnesses. So there you have it. That's the basic process for a jury trial involving a sexual assault matter. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.